May it please the court, Josh Harrow for the appellants, Harrow's Auctions. This case, excuse me. This case involves the submission of a bid proposal in response to a solicitation for auctioneer services. The appellee disqualified that bid.
Rebuttal time.
Sorry, I want to reserve 5 minutes for rebuttal.
Fine, thank you.
The appellee disqualified that bid, and the appellant requested an appeal to the Board of County Commissioners, but that request was denied, and a final rejection was entered. Then the appellant filed a 4-count complaint, and the issue in this case is whether the appellant was required to file a petition for writ of certiorari when the appellee refused to consider the appellant's bid proposal. There was never a formal administrative hearing. No representative appeared before the BOCC to argue its position. The appellee acted arbitrarily when it rejected the appellant's bid on the basis that it was non-responsive. The only action taken by the appellee was to formally award the auctioneer services and reject all the other bids. There is no quasi-judicial action that would be subject to a petition for writ of certiorari. Because the appellant's bid was just merely disqualified because it was non-responsive.
Basically, the situation you have here is you got the license in the wrong entity. Is that right? There was a change of entity that sort of went through 3 entities as far as I could tell.
There was a technical deficiency. The name was changed. It went from Golden Gavel Auctioneers to Harrow's Auctions.
But at the time your client filed their bid, the requirement of that auctioneer's license, the technical entity that was the biddee, or the bidder, I guess, didn't have the license. It was sort of in the predecessor entity. Am I right about that? Or worse than that, I think maybe the state of Florida hadn't transferred their records yet.
It was just a transfer of records. It was submitted. The name change was already in place. It was just that one document showing that the name was amended. That was the only thing that was left out from the bid. There's no question that they were licensed.
Now, here's the bigger problem, though. The issue about whether or not you should have brought this by writ of certiorari within a certain time frame, and that you didn't do it, you waited 4 years to bring an appeal.
The issue with that is that there was no quasi-judicial action for a petition for writ of certiorari. There was only an exchange of correspondence.
Well, let's focus on that. Why is it not a quasi-judicial function? Help me out with that.
Well, there was no notice and hearing, and it was a personal decision based on Ms. Patricia being the county administrator at the time, and Ms. Lulu Banks, the director of procurement services, not the Board of County Commissioners.
Okay, but you're dealing with an agency that made a recommendation that basically ought to be denied. It's an executive type of function. There was no, there was really no other. Am I mistaken in that? Let me take it one step at a time so I don't confuse you. When the actual bidding was rejected, who took care, who made the decision to deny your bid?
That was Ms. Patricia Bean and Ms. Lulu Banks. It was a personal decision. It was never, the decision was already made, and it was just forwarded to the Board of County Commissioners for a formal announcement of who they're awarding the bid to, and they just rejected 5 bids. There was no opportunity, no representative appeared to make any arguments of what happened with the documentation showing that Harrow's Auctions had the valid AB license, which allows them to do business as an auctioneer in the state of Florida.
Did you have an opportunity when you first found out that that bid was rejected? Did you try to appeal it, or did you try to bring it to their attention that this was a wrong decision or anything of that nature to at least to further your...
There was an attempt to appeal to the Board of County Commissioners, but the decision to just transfer that to the Board of County Commissioners, the determination was already made prior to the appeal. November 17th, the letters attached to the complaint, it's part of the record, saying that we're just going to forward this to the Board of County Commissioners, the determination's already been made, and after that was when the appeal to the Board of County Commissioners was made. It was 3 days later.
Okay, but and I'm trying to find out the timeline. During that period of time, did you attempt in any way, or when even the Board of County Commission made a decision, did you try to, at that point, at any time, did you try to appeal or have the decision be reconsidered?
Yeah, there was numerous correspondence between my client and the county to try to clarify the situation. The documentation was provided, in the beginning, the documentation was provided saying, we have the license, and it even came from the state of Florida saying they have this license. They can do business in the state of Florida.
And you raise an interesting point. Let's go back to that. Didn't they give you an opportunity at least, okay, here's what it is, you have to have this, please give us proof of that? And in response to that, I think your client said, well, I'm getting, the department, I'm getting the runaround. Wasn't there you were placed on notice to try to clear this problem, and really no action was done by your client to try to clear that issue? The
only notice was in the solicitation itself, which sets forth the rules and procedures that you have to follow to submit a bid. My client, there's numerous correspondence sent, and there was never really a letter by the county saying, this is what we're looking for, please provide this documentation. My client took upon itself to provide that. It contacted the state, and it sent it to the county saying, here it is. And there was even follow-up letters, and all those letters, that string of correspondence is attached to the complaint. It's part of the record, and it could show the efforts my client took to show that it did have the appropriate licenses to do business in the state of Florida. And in Overstreet Paving Company versus Department of Transportation, 608 Southern 2nd 851, this court held, if a low bidder provides prima facie evidence that it submitted a complete bid, any reasonable person would conclude that it was arbitrary for a governmental agency to reject that bid merely because a technical document cannot thereafter be found. This court further held that there's no public interest in disqualifying low bidders for technical deficiencies, and there's a strong public interest in saving tax dollars.
Well, let's accept that. The issue is when an executive decision by staff was made to disqualify the bidder, the question becomes what is your avenue of relief? And you did have it was on the county commission agenda. The disqualification was an agenda item.
I agree, it was on the agenda, but at that point, if you look at the previous correspondence, the determination was already made by individuals that this bid was going to be rejected.
By who? Staff.
It was a staff decision. It was an executive decision that wouldn't...
Staff's not the final word, is it?
It was said a final administrative decision, and there was no opportunity for my client to appear before the Board of County Commissioners and present its position. Its decision...
So it was noticed on the agenda for a BOCC meeting?
The letter says that it's going to be heard, but there was no... My client never said this is the hearing.
You could present... Did your client show up?
My client was not there.
Did not show up at the BOCC?
No, there was no opportunity for my client to be heard. On November 17th...
Did your client show up?
No.
Thank you.
On November 17th, the decision was already made by the staff that this was rejected. The bid was going to be awarded to a certain winner, and all other bids are going to be rejected.
Because Mr. Harrow, I think Judge LaRose he's following up on my question. It's like, what effort did you take to say, listen, we dispute that. Anything that you have done, especially when you knew that it was going to be considered, because your client did receive notice that this is going to be before that. Anything that you have taken needs to put them on notice. We have a concern about that. Anything like that.
There was numerous letters. First, I believe the letter was saying, we have the documentation, we'll provide it to you. And there was another letter still disputing the county's finding and saying, here is the documentation from the state of Florida. We have the appropriate licenses.
Okay, no, and I understand all that, but finally when you get a thing saying, listen, we're going to make a recommendation that your bid is going to be rejected, wouldn't that at that point think, uh-oh, we better show up, we better tell these people, we better... Nothing like that was done in this case.
But there was no notice opportunity for my client to be heard. Whether my client did or did not show up, there was no, this is when you have an opportunity to speak. My client wasn't allowed, there was no opportunity. And the appellate relies on the modeling case, which distinguishes between executive and quasi-judicial actions. For it to be quasi-judicial, there has to be a notice and hearing, and it can't be a personal decision. In this case, there's no notice and opportunity. There was an opportunity for my client to appear and say, this is what happened. And the personal decision for the bid was made by staff. The county administrator and the director of procurement services, not the Board of County Commissioners, made this determination. This is administrative action that's not quasi-judicial. To hold otherwise would mean that parties need to have a counsel anytime they deal with the county, and whether it's procurement services or another sort of public function, and that would pretty much be oppressive to have counsel at every step of the way. And in Share and Company versus Board of County Commissioner, Dade County, 188 Southern 2nd, 871, the appellant filed a petition for writ of certiorari to challenge an award of lease of storage space by the Board of County Commissioners, and the court held that it wasn't subject to certiorari review because there was no judicial action.
And Mr. Let me kind of digress. Let me kind of shift things around a little bit. Let's push the certiorari issue aside. How about the county's argument that it was really appropriate for the court to dismiss your complaint because, quite frankly, there's no way that you could have stated a cause of action. You made this bid and you filed, I guess it was a 4-count complaint for breach of contract. There's really no contract here. It's basically an offer for a bid. Number 2, fraudulent inducement to enter into a contract. Based on what's in the file, it doesn't appear to be anything of that. 3rd, negligent misrepresentation. Where's the negligent misrepresentation? And fraudulent misrepresentation. So how about, pushing aside the certiorari issue, how could you respond to the county's argument that you really could not state a cause of action under the complaint that was filed, so the dismissal was appropriate?
Well, I believe in the transcript of the trial court, the court held that there could be an action for the misrepresentation and the fraudulent inducement, and I believe the exact verbiage was, it's too little, too late. There's an issue with the misrepresentation because they're supposed to follow the rules and procedures in the solicitation that was handed out to the auction bidders. They're supposed to accept the highest bidder following those rules, and they're supposed to consider the bids submitted by qualified bidders.
And so that's the question, is that number 1, is it a qualified bid? That's one of the issue. And secondly, when you make a bid, that's basically an offer. Hey, I'm giving you an offer, please accept it. There was never an acceptance from the other side. So how can there be a claim for a breach of contract? Let's take it one step at a time. Breach of contract. Where are the elements for that, given the facts of your case?
Well, the offer would be when they hand out the solicitation. The acceptance would be when the bid is given to the county, and then the exchange of services for monetary compensation. That would be the contract. These issues were never examined by the trial court. We never got that far, and the fact should be taken as true if it was remanded to the court to examine those counts. And I believe the lower court has already held that some of those counts could have merit. So we're asking that the motion to dismiss be reversed and remanded for further findings. Thank you.
Thank you, Mr. Harrell. You'll have 5 minutes on rebuttal.
May it please the court, Stephen Todd for Hillsborough County. What makes this lawsuit subject to dismissal is twofold, as the court has really covered, and I'll try to limit my argument accordingly. Is first, as to the waiver of their cert remedy, not only waiver, but they waited over 3 years, almost 4, before filing suit, as Judge Levins aptly noted at the conclusion of our hearing on the motion to dismiss. And secondly, that in addition to that, our tipsy coachman argument is that Harrow's did not and could not comply with the county's specific bid requirement to produce an auctioneer's license, and I'll refer to the record, page 17, paragraph 30.6 of our contract specifies minimum qualifications for all bidders. 30.6 says bidder shall possess the following valid licenses. The second bullet point says auctioneer's license, open paren, AU and AB licenses, close paren. The AB license is the license at issue. They did not comply, and the notable part in the record here is that the previous entity, as that previous entity was listed on the AB license, did not exist as of 4 years prior to the bid being placed to Hillsborough County. So they had 4 years within which to make that change instead of scrambling as of the time that they were placing the bid with Hillsborough County. So it wasn't a situation where they were waiting on the state to perform some ministerial act It was a situation where they sat on their hands and waited those 4 years from 2004 to 2008, within which time they were certainly well able, according to this record, to present that application to the state. Can you change our AB license to Harrow's Auctions Incorporated?
Admit, even if they waited that 4-year period, it was really a ministerial act that needed to be accomplished with the state.
Yes, sir.
Okay.
It was.
And I'm assuming your notice of bid has a waiver provision that allows the county to waive certain requirements, and probably could have waived this non-compliance if it so desired.
It is to a certain extent a judgment call, but when you have this language in the contract that says it's a minimum requirement to produce an AB license, you make it a relevant and an integral part of the bid documents that all of the bidders have to comply with. Bidder A has to comply with it, and they comply with it, but they have to go to some trouble to do it. And yet they look at Harrow's Auctions and see they haven't had to comply with it. They get away with submitting a bid package with a different name on it. Where's the fairness in the process? The county's got to be the arbiter of the integrity of the county's bid process, since the county is subjected to criticism all the time. It's newsworthy stuff if the county does not comply with its own bid processes. The news reporter looks at the bid language. Well, what about the AB license? Why didn't you require that they produce an AB license? County procurement director, county administrator, board of county commissioners. So this is certainly an issue that's sensitive to the county.
Let me follow, because I've asked that to Mr. Harrow, but in terms of when they were notified that they did not possess the AB license that's necessary in order for it to be qualified, did they have an opportunity to come forward and at least let the county, hey, you need to, this is a mistake, you need to rectify this mistake? Walk me through the opportunities that they had at least to raise this to the county's attention.
The opportunities were on two levels. One was on the executive level, and the other is on the quasi-judicial level. On the executive level, there were several letters that changed hands that I described in detail in my statement of facts in the case. That it would start with Harrow's Auctions saying, can you reconsider? In the letters, they make reference to a mix-up, a minor irregularity, a minor technicality as being their concern about the issue. The county looks at it carefully and says, no, we have a specific language here that requires that you comply by producing an AB license in your name. They respond and say, we're going to go to the state, we're going to fix this, can't you just wait on it? The county says, no, basically you had 4 years to do that. I'm sorry, you're out of luck. You should have submitted this with your name on it instead of waiting 4 years to get this corrected with the state. Then there was a third back and forth that resulted in the county again denying it. The county did consider the application very carefully, but it was always down to the bid language because the county has to protect the integrity of the process. Finally, that's the end of the executive process, and the record reflects on page 116 of the record, the Harrow's Auction is given a letter from the county administrator, Patricia Bean, and told that they have an opportunity to appeal. The agenda item is prepared for the Board of County Commissioners' regular meeting scheduled for December 17, 2008. This letter is notice of our final administrative action, thus ending the executive act of the county. And it says you may appeal this decision to the Board of County Commissioners. You must submit your request to the Director of Procurement within 5 days. The record at 117 is their letter appealing to the Board of County Commissioners. The record at 118 through 120 is the board's agenda item placing Harrow's on notice that here's your chance, and thus complying with the requirement of the modeling case that the county supply notice and hearing in order to constitute a quasi-judicial act. So the county had both executive, quasi-judicial from that point. Judge Levins is correct. that their remedy is to file a petition for cert within 30 days if they disagree with the Board of County Commissioners' quasi-judicial decision.
And Mr. already has indicated to us that his client, no one showed up at the Board of County Commission meeting, correct?
There is nothing in the record on that, so I won't speak to that, Your Honor.
Okay.
Okay?
All right.
All right. But we did produce our notice, and we did give the opportunity to be heard. And certainly they would be sensitive to that after they submit their request for a hearing. Our notices are publicly rendered, available to the public online, in writing, on a piece of paper in front of the boardroom in advance of commission meetings. So certainly we satisfied the requirement that we provide proper notice. On the tipsy coachman argument, Your Honors, as Judge Kazam, you alluded to, they simply can't get there with the arguments that they presented. Breach of contract doesn't work because there's no contract. They attempted to argue that in their initial complaint. I discussed that with counsel. He amended the complaint, but retained the argument that there was a breach of contract. Once again, if we have to deal with a breach of contract from every bidder for contracts, we're going to be up here a lot more often. Simply is no end in sight to what we're going to have to defend if a potential bidder who's disqualified early in the process is entitled to bring a breach of contract action. The negligent misrepresentation, fraudulent misrepresentation, and the fraudulent inducement to enter a contract allegations simply rely upon their argument, their premise in their pleadings that they were a successful bidder, that they should have won the bid process, and that the county's decision to disqualify them was the fraud, was the fraudulent inducement, was the misrepresentation. That's it. That's all they're alleging. So on the facts that they're alleging, they cannot state a cause of action for which relief may be granted. Thus, our tipsy coachman argument that we preserve below. So trial court was correct below on both bases that we argued, both on the cert argument and on the failure to state a cause of action. We request for that reason that the decision below be affirmed. Thank you.
Thank you, Mr. Todd. Mr. Harrow, rebuttal.
First, I want to address the issue of that the appellant couldn't comply pursuant to the terms of solicitation. This is a technical deficiency that this court has overlooked in the past. The appellant did possess the appropriate license. It was provided to the county, and this court has already held that there's no public interest in disqualifying bids for technical deficiencies. My client took numerous opportunities to resolve this issue with the county. On October 6th, there was a notification sent by the county that certain information was missing. 4 days later, my client obtained a letter from the Florida Department of State showing this name change was valid and that the appropriate licenses were possessed. On October 30th, the county rejected this documentation. The very next day, my client sent a letter asking this to be forwarded to the Board of County Commissioners for further determinations. On November 17th, the county rejected this bid by staff determination. They rejected it, and they said they were going to send that rejection to the Board of County Commissioners for a formal announcement. On November 20th, my client asked for appeal in front of the Board of County Commissioners. Then instead, on December 17th, without notice and opportunity, it's just rejected. It's announced, the bid winner is announced, and then 5 other bids are rejected. The merits of this case were never determined by the lower court, and from the lower court's rulings, it seems that there could be something to stand on. Those issues were never addressed. And the allegations of the complaint, they must be taken as true in dealing with a motion to dismiss. So we're asking it to be remanded for further determinations. Thank you.
Thank you both.
Our next case will be Frengel versus Kay.